Well, good evening, everyone, and I am pleased and honoured to be able to introduce our speaker this evening, Professor Jenny Payne. Jenny was for a number of years Professor of Corporate Finance Law at Oxford, but for the last 6 months has been Warden of Merton College, one of the oldest colleges in the university and one of the most beautiful and the most distinguished. I've had the pleasure of teaching alongside Jenny, and I know just how compelling her lectures normally are, and I'm really looking forward to this evening. Jenny.
Thank you very much indeed, Richard, and thank you very much for the invitation to be here. I'm absolutely delighted to be giving this lecture. I should apologise in advance, I'm afraid, for a slightly hoarse voice. I'm just coming to the end of a head cold, but I'm sure my voice will last for the duration of the lecture. So the topic tonight is the future of UK capital market regulation. And by way of introduction, the last few years have seen a significant focus on capital market regulation in the UK. In this lecture, I will discuss why this topic is important, why it's the focus of attention at the present time, what changes are in progress, and how we should assess the UK capital market regime. Of course, the moment when a company decides to make its securities available for sale and purchase on a trading venue for the first time is pivotal for any firm. The process gives investors in that company the possibility of trading their shares on the public markets. However, going public is not the right decision for every firm at every point in time. It brings opportunities in terms of a vastly increased pool of investors, but also significant new costs and regulatory requirements. Historically, most companies have gone public through large equity raising events known as IPOs. Indeed, IPOs have often been understood as the typical culmination of successful growth, an almost inevitable step for any company after reaching a certain stage of development. Typically, companies have gone public by listing their shares on national exchanges, usually in their home jurisdictions, but often also in key markets such as the US or indeed UK. More recently, however, 3 key trends have emerged to challenge these historical assumptions. First, it would seem that companies are taking increasingly longer to go public, or even forgoing this opportunity entirely, regardless of how much they've grown and how big they've become. Venture-backed private firms are increasingly likely to be acquired instead of exiting via an IPO, and fast-growing companies display an increasing preference for raising capital in the private equity and debt markets. Ultimately, more and more companies appear willing to remain private indefinitely, a phenomenon that's particularly prevalent amongst companies operating in the tech sector. This has been coupled with an increasing unwillingness on the part of founding shareholders to give up control over the companies that they have launched. As such, even companies, when they do decide to go public, their founders might scour the global capital markets in search of jurisdictions where trading venues welcome firms deviating from the one share, one vote principle. In truth, cross-listing is nothing new, however. Companies have long cross-listed in jurisdictions with lower trading costs, greater liquidity, better price competitiveness, more robust rules, or indeed added prestige. But in the last few decades, national exchanges have faced increasing competition from growing numbers of alternative and often less regulated trading venues. Finally, it would appear that companies looking to make their shares available for sale and purchase on public markets for the first time are increasingly interested in methods of going public that can fairly be described as alternatives to traditional IPOs. And one example of this, which we've seen in recent years, particularly in the US, is the use of special purpose acquisition companies, or SPACs as they're rather charmingly known, which are vehicles for raising equity finance and eventually going public, which can operate as an alternative to the traditional IPO structure. These trends have become particularly visible in a world shaped by the rise of tech unicorns, whose business models and expectations increasingly dictate the evolution of global capital markets. For some, these trends have also confirmed the long-foreseen death of the traditional IPO model. Indeed, while IPO activity was soaring in the 1990s and early 2000s, the last 2 decades have generally witnessed a significant decrease in IPO numbers. This might then be the perfect opportunities for countries to rethink how they support their public markets and to look to the future of the IPO and the capital markets more generally. And Brexit has provided the UK with the means of introducing significant changes if it wishes to do so. Having exited the EU on the 31st of December 2020 and thus ended the requirement to follow EU regulations, I think it's fair to say that the UK is embracing the opportunity to assess whether its rules still offer the right regulatory regime for the UK capital markets. And we've seen a significant amount of new legislation being put in place or indeed in train in relation to IPO regulation in particular. The starting point for this self-reflection was the 2021 UK Listing Review, often known as the Hill Review, which recommended significant changes to the UK regime and which the government subsequently confirmed its intention to take forward. And this in turn has prompted a series of consultations on capital market reform. As I say, these have already resulted in changes to the UK regime, with more changes planned. However, countries should resist the urge to radically change capital market regulation in an attempt to satisfy the demands of tech entrepreneurs. Capital market regulation is a delicate balancing exercise where the needs of companies for quick and easy access to the public markets must be weighed against the need to protect investors, and particularly retail investors, from being deceived into making potentially ruinous financial decisions. Indeed, the reform proposals emphasise both the need to broaden the opportunities for companies to raise capital on the public markets and the importance of facilitating offers to a wide range of investors, including retail investors. There is, however, a tension between those two aims, as you might well imagine. The changes to the UK capital markets are still ongoing, so their full extent will only become clear in time. I'll therefore assess the changes to date and consider the direction of travel. What does seem clear is that once all the changes are in place, the architecture of the UK regime will look very different from its EU equivalent. This will undoubtedly complicate offers being made into both the UK and the EU, as two sets of distinct provisions will need to be satisfied. Whether the changes will satisfy the aims of the UK government, especially regarding regulatory competition, of which more in a moment, remains to be seen, but I think there are reasons to doubt that it will have this effect. Now, given the time that I have available this evening, I'm going to have to be selective about the topics that I discuss, since the volume of consultations, reform proposals, and legislative and regulatory provisions that have emerged in this context in the last couple of years have been vast. In particular, therefore, I'm going to focus my attention in this lecture on the reforms that have been proposed to the UK regime in relation to the IPO sector. And that's because this has been the significant focus of the UK government's reform plans, but also because I think many of the themes and issues that arise in this context apply more generally to the proposed reforms of the UK capital markets. So the first question then is why IPO regulation might be needed in the UK at all. And as I've said, an IPO has traditionally been seen as a rite of passage for most companies. The upside is a vastly increased pool of potential investors and an exit route for existing shareholders. The downside is that when going public, companies become subject to substantial additional regulation, depending on the exact markets that they ultimately choose to list in. In particular, at the IPO stage itself, companies need to disclose a huge amount of information about the company and its securities via a prospectus. Further regulation then follows once the company has succeeded in offering its securities to the public and is listed on a public market, in terms of both ongoing disclosure obligations and conduct rules such as the market abuse regime. The predominant purpose of this regulatory burden is investor protection. So, for example, the mandatory disclosure regime that is put in place at the IPO stage is intended to protect investors, particularly retail investors, and to enable them to make informed choices about the investments they're about to make, resulting, hopefully, in efficient resource allocation decisions. This model has some downsides, of course, particularly for SMEs, which are unable to bear the costs of that regulatory burden. Investors also lose the opportunity to invest in those companies, and in particular miss the opportunity to participate in some of the early stage gains that those companies may make. But there are trade-offs here. Reducing the regulatory burden might allow more SMEs to offer their shares to the public, but that's likely to be at the expense of investor protection more generally. So any regulatory model needs to balance those competing goals. The UK has traditionally been able to offer an attractive environment for companies looking to go public, but the desirability of the UK public markets has recently been called into question, not least in that 2021 Hill Review that I mentioned earlier, and which kick-started the latest rounds of consultations and reforms. One significant aspect of this is, as I've mentioned, that IPO numbers in the UK have fallen significantly in the last 20 years, particularly after the global financial crisis of 2008. Now, of course, macroeconomic factors like business cycles, volatility, and interest rates all have significant explanatory power when it comes to fluctuations in IPO numbers. But it's worth considering three other explanations for the decline of the IPO model. First explanation for the decline in numbers may be the growing volume of IPO regulation. It's generally accepted that the regulatory burden on public companies has increased significantly over the last 20 years or so. The response to the global financial crisis was to a large extent greater regulation of the public markets and of the issuers seeking to make use of them. This was undoubtedly the response within the EU, which responded to the 2008 global financial crisis with a tsunami of capital market regulation. And of course, prior to Brexit, the UK was bound by that regime too. Second explanation for the decline in IPO numbers may be the rise in alternative options for companies wishing to access new pools of financing for their securities beyond their existing debt and equity holders. And two developments deserve particular comment in this regard: the development of private equity and the growth of equity crowdfunding. Private equity enables companies seeking an injection of capital to receive this from a private equity firm rather than from the public markets. Private equity has grown enormously in the last 30 years or so, to the point where it's said to rival the public markets as a source of financing. Now, the term private equity can encompass a wide variety of transactions, from seed capital and venture capital, which focuses on young and emerging companies, to the provision of finance for mature firms. And on that latter end of the spectrum, that might involve the purchase of publicly traded companies, which are then taken private, or the injection of capital into a mature private company as an alternative to an IPO. Equity crowdfunding, by contrast, is a more recent innovation as a source of equity capital for companies. It can take many forms, but one use is the ability of the public to invest in the shares of a private company via an online platform. Equity crowdfunding of this kind is in some ways similar to an IPO, as it can enable the company to receive equity financing from the public. But unlike IPOs, the company in question need not be a public company, and indeed equity crowdfunding to date has most commonly been used by very small and early stage companies. The rise of these alternatives to the IPO model interacts with the first explanation I gave you, the regulatory burden explanation, since both of these options offer a lower regulatory burden than the IPO model. In relation to private equity, there's no offer to the public. Retail investors cannot invest directly into this asset class, so there is no need for a prospectus. The only shareholders are the PE fund, private equity fund, and the directors of the company. In relation to equity crowdfunding, there is an offer to the public, so technically a prospectus would be required, but equity crowdfunding has made use of a statutory exemption from the need to produce a prospectus, where the amount being raised is under €8 million. So in practice, therefore, the sums raised via equity crowdfunding are very small, very modest. To date, equity crowdfunding is not regarded as a full competitor to the traditional IPO model. Rather, it's seen as addressing the financing needs of a very different sector of the economy, namely SMEs and MSMEs. Third explanation for the possible decreases in IPO numbers in a particular country, such as the UK, might be the product of increased competition amongst global trading venues. As cross-listings have become easier and more popular and listing options have become more abundant, certain countries may witness a decline in their public markets. And in the run-up to the Hill Review, there was certainly a sense that other jurisdictions are winning at the expense of the UK capital markets, and that the regulatory regime was playing a significant role in this regard. The Hill Review stated, why do we need to act? Although listing on the premium listing segment of the FCA's, the Financial Conduct Authority's official list, has historically been globally recognised as a mark of quality for companies, the figures paint a stark picture. Between 2015 and 2020, London accounted for only 5% of IPOs globally. The number of listed companies in the UK has fallen by about 40% from a recent peak in 2008. We face stiff competition as a financial centre, not just from the US and Asia, but from elsewhere in Europe. So, what has been the government response to these perceived threats to the UK IPO market? Well, as I say, the response to the Hill Review has been a slew of other consultation papers, proposals for change, and regulatory and legislative reform, some already in place, some yet to come. The reforms to date have come in two main waves. The first wave was in 2021, shortly after the Hill Review, when the Financial Conduct Authority introduced changes to the listing rules to pick up some of the suggestions made by the Hill Review for specific changes. They did so particularly in relation to SPACs that I've mentioned earlier and dual-class shares. These were a number of targeted and really quite limited reforms, as I'm going to explain shortly. The major changes really came in 2023 with the Financial Services and Markets Act 2023 and the Public Offers and Admissions to Tradings regulations of the same year. Now, as I'm sure you know, the European Union Withdrawal Act of 2018 ensured the continuity of EU law in the UK after Brexit by onshoring then existing EU law as part of UK law. So the EU prospectus regulation, which is the main regulatory tool overseeing IPO regulation, became a new body of UK law post-Brexit. Some technical amendments were necessary, for example, to transfer the functions exercised by the European Securities and Markets Authority to the UK regulator, the Financial Conduct Authority, but otherwise, as at the date of Brexit, UK and EU law were aligned. What the Financial Services and Markets Act 2023 seeks to do is to create a new competitive financial framework for the UK by revoking retained EU law relating to financial services and replacing it with legislation designed specifically for the UK market. It establishes a framework for the revocation of all retained EU law relating to financial services and a transition to the new requirements which will be placed under the Financial Services and Markets Act 2000 regime. Now, certain of the Act's provisions came into force shortly after Royal Assent in 2023, such as a new objective for the Financial Conduct Authority requiring it to focus on international competitiveness and medium to long-term growth. But others, most others in fact, will come into force at a later date to be specified by the Treasury. The aim is to take a phased approach to the revocation of retained EU law and its replacement by either regulators' rules or legislation as appropriate. It's expected that individual pieces of retained EU law will not be revoked formally until such time as new rules have been put in place by the UK regulatory authorities to replace them. So we don't have a sunset clause included in the provisions. Given the scale and complexity of the task that faces the UK regime, the revocation of retained EU law is going to occur in stages and is likely to take a number of years. The government's policy position is to prioritise reform of legislation where there is the greatest opportunity for beneficial reform. The listing regime is one of these priorities, and the Public Offers and Admissions to Trading Regulations 2023 are intended to create a new regulatory framework for the offering of securities to the public and admission of securities to trading in the UK, replacing the EU-derived prospectus regulation. Once the substantive provisions contained in these regulations come into effect, they will introduce significant changes to the UK regime. The regulations provide the Financial Conduct Authority with general powers to make rules in this area. They delegate to the Financial Conduct Authority a significant degree of responsibility for creating a regime that will be calibrated specifically to the UK markets. To a large extent, the detailed provisions will therefore be contained in the Financial Conduct Authority's rulebook. That will be a significant change. It'll be in the rulebook rather than in legislation. The FCA is still consulting on these rules. The expectation is that they should be in place by summer 2024, with the regime itself coming into effect a year or so later. Now, when it comes to reviewing these various proposals, consultations and reforms that have flowed from the Hill Review, it's clear that two of the three explanations that I gave you for the drop in IPO numbers have played a significant role in shaping the government's prospectus reform proposals and the changes made by the Financial Conduct Authority to its listing rules, namely a concern to alleviate the regulatory burden and a desire to address those regulatory competition issues. By contrast, the proposed reforms give comparatively little attention to the other reason for the decline in IPO numbers that I've described, namely the rise in attractive alternative capital raising options that are available to companies, particularly the opportunity to make use of private equity. So in the next section, what I'm going to do is I'm going to seek to give you an overview of the main changes that are proposed. It will have to very much be an overview given the time available. It would take me indeed several days to go through the detail of the myriad changes that are proposed. But in doing so, what I'm going to do is separate them into those predominantly focused on reducing the regulatory burden and those which are predominantly aimed at regulatory competition. Although, of course, there is a substantial amount of overlap between those two categories. Indeed, reducing the regulatory burden is of itself intended to make the UK a more attractive listing destination. So let me start by giving you two examples of changes that are intended to tackle regulatory competition. And I'm going to do the regulatory competition ones first because these examples arise from the first wave of reforms that I mentioned, the 2021 reforms, straight after the Hill Review. They've already been introduced, therefore. The changes relating to regulatory burden on the whole have come in the second wave and therefore have yet, to be implemented. So, two examples I'm going to give you in relation to regulatory competition. The first example relates to those special purpose acquisition companies that I mentioned, SPACs. So SPACs, as I've said, have become an increasingly popular method of corporate acquisition, particularly in the US. A SPAC is a company formed to raise money from investors, which it then uses to acquire an operating business. SPACs are therefore founded by a management company and are then listed on a stock exchange through an IPO. At the time of the IPO, the SPAC itself has no tangible assets or business operations. The only asset consists wholly or predominantly of cash, and therefore investors in the SPAC are effectively investing in the ability of the management team to find an appropriate target to acquire. So the sole purpose of the SPAC is to identify and purchase a business that is consistent with those investment objectives. One benefit of using a SPAC is that companies going public via this route need only be acquired and don't need to undertake the burdensome listing process that a traditional IPO requires, thus reducing the usual IPO timeline. Now, the Hill Review noted that there were far fewer of these things, SPACs, available in London or being used in London compared to competitor markets, and identified a number of regulatory provisions within the UK regime which were acting as a constraint on the use of SPACs in the view of the Hill report. In particular, the acquisition is treated as a fundamental change to the nature and business of the SPAC and is thus classed as a reverse takeover. This requires a relisting of the enlarged entity, which includes the cancellation of the existing listing and the need to go through the usual eligibility process to achieve a relisting, including Financial Conduct Authority approval of the relisting prospectus. A particular deterrent identified by the Hill Review was the fact that the listing rules contain a rebuttable presumption that a SPAC's shares will be suspended from trading once it announces a potential acquisition. Investors in the SPAC are therefore unable to sell their shares and realise their investment until the investment is complete and a prospectus is published. So there have been a series of reforms introduced into the UK relating to SPACs. What these have done, however, is recognise the fact that while SPACs may bring benefits for issuers, this can often be at the expense of investor protection. The main concern is that SPACs might encourage the listing of low quality or less mature companies on the London Stock Exchange through this SPAC route, due to the inevitable pressure on the management team of the SPAC to spend the newly raised cash on a deal given the limited time available in which to find a deal or instead repay the cash to the investors. As a result, the changes that have been introduced by the Financial Conduct Authority are relatively minimal, and rightly so in my view. So there is a presumption that the suspension of shares will be removed for larger SPACs, those raising at least £100 million at the initial listing, as long as various additional investor safeguards are provided. These include a redemption option allowing investors to exit a SPAC prior to any acquisition being completed, ensuring that the money raised from public shareholders is ring-fenced, requiring shareholder approval for any proposed acquisition, and a time limit on a SPAC's operating period if no acquisition is completed. So these reforms, as I say, are pretty limited, but the FCA is right to be cautious. Concerns remain over disclosure standards and the share price performance of this model. It's not clear that SPACs are the proper structure to increase the number of IPOs while protecting investors. And indeed, what we've seen in the period since the Hill Review is the US tightening up its obligations in relation to SPACs to take account of investor protection concerns. So that was the first example. The second example that relates to regulatory competition relates to dual class shares. So these operate as a different kind of incentive for companies to use the public markets. Rather than seeking to reduce costs, dual class shares offer founder shareholders an opportunity to retain a degree of control over the company even after there has been an offer to the public. In a traditional UK IPO listing on the premium market with a one share, one vote structure, founder shareholders and corporate insiders generally retain a relatively small proportion of the equity shares and therefore a similarly small proportion of voting rights and control. Dual class shares offer the opportunity to hold share classes with weighted voting rights. The weighted voting rights enable those insiders to retain a degree of control over the company that's therefore disproportionate to the equity shareholdings after the IPO. Now, although UK institutional shareholders have traditionally been against the introduction of such shares in publicly traded companies, the recent revival of dual class shares in the US and reforms in leading financial centres in Asia to accommodate listings with such share structures has brought this issue to the fore again in the UK. Those in favour of dual class shares point to the benefits of greater market flexibility, greater capital flexibility, and the benefits of persuading entrepreneurs to utilise the public markets, giving investors, including retail investors, the opportunity to invest in companies that might otherwise remain in the private sector and enabling founders to pursue a longer-term vision for the company. Those opposed to such shares cite the problematic implications that can flow from separating shareholders' control from their cash flow rights and corporate governance concerns given that such structures can entrench founder shareholders and reduce or prevent investors from having a say and holding management to account. So 2 changes have been introduced to try to address this issue. The first change is a decision to reduce the level of shares required to be in public hands at the time of listing from 25% to 10%. So that's intended to facilitate the greater retention of shares in the hands of founder shareholders. The second thing that has happened is, as the Hill Review recommended, that dual-class share structures should be eligible for admission to both the standard and premium segments of the London market. That has been introduced, but with a number of conditions attached. In particular, the conditions include a maximum weighted voting ratio of 20:1, and the fact that those weighted voting rights can only be held by directors of the company and are only available in 2 circumstances: when the votes are being used to remove the holder of such shares as a director, and votes that follow a change of control. At present, this exception can only be relied on during a 5-year sunset period, but this constraint is intended to disappear when the new prospectus regime comes into force. And again, I think it's clear that those reforms are actually pretty modest in shape and size. So those 2 measures that I've mentioned, the ones to tackle regulatory competition, came in that, let's say, first wave of reforms in the aftermath of the Hill Review. They're pretty minimal changes, I think it's fair to say. They can be seen as largely tinkering at the edges of existing structures rather than introducing wholesale change to the regime. I think it's perfectly right that there is a desire to maintain investor protection standards, and it's understandable that the FCA chose, therefore, to introduce pretty modest changes in this regard. But of course, the consequence of such light touch reforms is that they are unlikely to address the regulatory competition concerns that the Hill Review raised. Okay, let me then move on to some examples that are intended to address the regulatory burden point, and I'm going to give you 3 examples here. But I think it's fair to say that the goal of reducing the regulatory burden is central to the government's prospectus reform proposals. So the first example that I'm going to give you is a separation of the concept of an offer of securities to the public and the concept of having those shares, those securities, admitted to trading on a particular stock exchange. One of the central proposals that is being put forward arises from a recognition that the current regime brings together those 2 different regulatory concerns: the regulation of public offers of securities and the regulation of admissions to stock markets. And these 2 are treated as sort of effectively being part of the same package. The idea of the proposed reforms is to treat these 2 concepts differently so that they can be addressed and on their individual merits. So an offer of shares to the public is usually accompanied by an admission of companies' securities to trading on the public market. The benefit of an admission to trading alongside an offer to the public is that, of course, you can then provide investors with a marketplace for the shares on which they can be easily traded, increasing their liquidity and value. It's common, therefore, to do both, but you don't need to do the 2 things together. Under the current regime, both an offer of securities to investors and an admission of trading trigger the need for a prospectus with all the mandatory disclosure requirements that come with that. Under the proposed changes, the offer of securities to the public is still going to trigger the need for a prospectus, subject to what I'm going to say in a moment. But unlike under the existing regime, there will be no automatic requirement for an issuer to publish a prospectus if it wishes to admit transferable securities to a regulated market. However, the FCA, the Financial Conduct Authority, will have the power to make rules requiring a person to publish a prospectus before applying to admit securities to a regulated market, such as the London Stock Exchange's main market. This is designed to give the FCA more flexibility to decide when a prospectus is, and crucially isn't, required, when admitting securities to the larger securities exchanges in the UK, rather than dispensing completely with the requirement for a prospectus. The intention is that giving the FCA an enhanced remit and empowering it to make changes where it deems necessary will give it flexibility to manage the process and to reduce the overall regulatory burden that companies face. So this would no doubt be useful in allowing the Financial Conduct Authority to grant derogations or relaxations for smaller and repeated secondary fundraisings. For example, if you've got a company that has already gone through an IPO process and had its shares listed on a stock market, and then it seeks to raise further money by issuing more shares, it may be that those further issuances of shares do not need the same full prospectus requirement as at the IPO stage. And indeed, fundraisings by small and medium-sized enterprises may not need the same level of scrutiny. And indeed, the FCA may decide that in emergency equity raises, the same level of prospectus requirements are not necessary. So the FCA will have a significant degree of flexibility in deciding when a prospectus will be needed. Now, we're still waiting for the final details on this, but this could cut some of the regulatory burden that companies face. What the FCA does or plans to do with this power will, however, be key to understanding the extent of the difference between the current regime and the proposed new regime. So that's the first example of a planned change that will reduce regulatory burden. Second planned change is a change to the circumstances when a prospectus will be needed. Now, I've just mentioned the fact that the proposals retain the requirement for a prospectus when you issue securities to the public. But we've always had a series of exemptions from those requirements. So it's traditionally been the case that even when you offer securities to the public, you may be able to bring yourself within an exemption and therefore avoid the need for that prospectus requirement. Traditionally, the exemptions have been focused on situations where the mandatory information that otherwise you'd get in a prospectus isn't necessary because the investors can be assumed to have it already. For example, you have existing shareholders receiving bonus shares or shares that are issued under employee share schemes, for example, or where they can be expected to access the relevant information for themselves, such as where the offer is being made to qualified investors, for which we can read sophisticated or institutional investors rather than retail investors. Or indeed, exemptions have existed where the cost of mandatory disclosure can't be justified because the size of the offer is too small. And in the UK, this has meant offers below €8 million are exempt from the need to produce a prospectus. And that, if you remember, is why equity crowdfunding avoids the need for a prospectus, but it also provides the cap, the upper limit on the circumstances when you can use equity crowdfunding. Or indeed, the size of the offering may be too small because the number of investors to whom the offer is being made is very, very small. And at the present time, if an offer is made to just 150 investors in the UK other than qualified investors, an exemption exists. So the proposed new regime broadly picks up and follows this structure with some changes. So one change is that we're converting all the euro figures into pound sterling, but there are some more significant changes involved. The first significant change is an expansion in the number of exemptions that are available. So, for example, there is a new exemption for offers to existing holders of securities subject to certain conditions, which is intended to facilitate preemptive offers such as rights issues and open offers. More significantly, while the cap on the size of offers below which no prospectus is required will move from €8 million to £5 million, a new exemption will allow for offers over £5 million with no cap provided, as long as the offer is made through a platform operated by a firm specifically authorised for this purpose. Public offer platforms, such as crowdfunding platforms, will be authorised and supervised by the Financial Conduct Authority. The use of these platforms is intended to enable the financial cap which has previously existed on equity crowdfunding to be removed, and to facilitate offers to the public for SMEs and MSMEs without the cost and burden of producing a prospectus above that existing €8 million cap. Excuse me. So it's intended to tackle the widely held view that SMEs are not well served in the present regime unless they can stay below the present cap of €8 million and make use of equity crowdfunding. This change is intended to vastly increase the opportunity for smaller and medium-sized companies to make use of equity crowdfunding and therefore avoid the need to have to comply with the prospectus requirements. This sounds like a good opportunity for SMEs, but what about investors? SMEs are high risk and give retail investors access to an exciting range of opportunities, but a high risk set of opportunities. The possibility of losing everything that you invest is very significant. The FCA is still consulting on the ways in which investors are going to be protected in this model. The proposals at present rest significantly on the FCA's oversight of the platforms through which the investments will be offered, and significant obligations being placed on those platforms to carry out due diligence on the issuers and indeed communicate that due diligence to investors. It's also contemplated that the primary liability for misstatements will lie with the platform itself rather than with the issuer. So there is a lot of change proposed in this space, and the details are still being developed. I think it's fair to say that we will only be able to determine whether that balance in terms of issuer opportunity versus investor protection are being properly managed once we see the final provisions. The third main tool that is available to the government to reduce regulatory burden is to look at reforming the mandatory disclosure regime itself. One of the most burdensome aspects of the current regime is the huge amount of mandated information that's required once the prospectus is needed. And that information has to date been largely historical and backward looking. This stands in sharp contrast, as I've already said, to other fundraising options, private equity, for example, and to a lesser extent, equity crowdfunding. The proposals that I've mentioned so far seek to reduce the circumstances in which a prospectus is needed, but at the heart of the regime is still the idea that once a prospectus is required, then a significant amount of disclosure is still going to be needed. There is relatively little change to the volume, form or content of the mandated disclosure regime itself, and indeed, as I'll mention in a moment, if anything, it's likely that the amount of information may well rise rather than fall under the new regime. So the overriding purpose of the prospectus in the new regime will remain much the same as it is now. In other words, to provide information which is material to the investor for making an informed assessment of the assets and liabilities, profits and losses of the issuer, and the rights attached to the securities. As to the form and the content of the new prospectus, the starting point for the Financial Conduct Authority is to largely retain the status quo. In terms of content, for example, the FCA has stated that the financial information currently required by the prospectus regulation is necessary information for investors seeking and to make an informed assessment of the issuer and its securities. And the assumption for its consultation process is therefore that this information will be retained. The FCA has sought feedback on this assumption and whether improvements can be made, and the final rules are still awaited. But it certainly seems that the starting point isn't going to be too significantly different from the current position. There are two areas I'm going to mention where there will be changes. Both of these, I think, though, will result in potentially increased rather than decreased disclosure. The first is the fact that the main market of the London Stock Exchange is currently split into two segments, the premium segment and the standard segment. The idea is that the premium segment comes with an increased set of requirements for issuers. But the differences between the two have narrowed over time. The new regime will bring that distinction to an end. Instead, the FCA proposes a new equity shares in commercial companies category, to which many of the premium listed principles, the higher set of principles, will apply, such as the requirement to follow the UK Corporate Governance Code on a compliance. So this new category, the commercial companies category, will basically use the higher of the two sets of disclosure obligations for all companies that intend to list on the main market. The second change is that, as recommended by the Hill Review, the new regime attempts to encourage the use of more forward-looking information in prospectuses. It might seem odd that investors, when they're trying to decide whether to buy shares, and obviously the thing they're trying to do is work out whether the shares that you're buying today are going to be worth more in a week or a month or a year's time than they are now. In deciding that, the information that you're being provided is largely backward-looking and historical. What investors want is forward-looking information, what's going to happen to the company, what's going to happen to the securities in the future. But an inherent problem with companies, issuers and their directors providing forward-looking information is that it is, expect, inherently speculative, and it may well be wrong. One disincentive for directors and others producing prospectuses which include forward-looking information is that they may face liability if they include forward-looking information which subsequently turns out to be inaccurate. In an attempt to encourage more forward-looking information, the new prospectus regime will therefore create a new liability standard for protected forward-looking statements. At present, the statutory enforcement regime in the UK for prospectuses employs a negligence-based standard with the onus on the defendant to prove that they were not negligent, so it's a particularly strong form of negligence standard. This is felt to be a potential disincentive for issuers and their directors in providing forward-looking statements. So the new regime, it's suggested, for these protected forward-looking statements will face a higher hurdle. If investors want to bring a claim for misstated protected forward-looking statements, a dishonesty or recklessness standard will be employed rather than a negligence standard. It remains to be seen whether this will indeed increase the amount of forward-looking information as the Hill Review intends. So what can I conclude, having given you that sort of canter through some of the changes that are being proposed by the government? Well, I think it's clear that this is a period of significant change in the UK public markets, but the full extent of those changes, as I've said, will only become clear as the various consultation exercises come to fruition. The current attention on reforming the UK regime, I would suggest, is timely, given the significant advantages of going public, both for companies and for issuers and investors. The UK should strive to make its public markets more attractive. However, as I've said, any reforms that are introduced need to balance the benefit to issuers from increasing access to the public markets and reducing regulatory burdens and costs, and the benefits to investors from increased options to invest in a wider range of companies, with the need to protect investors, particularly retail investors. That balance between opportunity and cost is something which is key, and as I say, that we will need to wait and see what the final set of reforms look like before we can make a judgment on that. There are real opportunities to reduce the regulatory burden here without reducing investor protection. There is a real attempt to address this issue, and as I say, there is the opportunity, there is the potential for some significant changes. I think particularly for SMEs, being able to access the public markets via these public offer platforms, the extension of the equity crowdfunding regime. But as I've said, much will depend on the exact details of the final regime when it is implemented. What is much less clear to me is whether these reforms will address the regulatory competition issues raised by the Hill Review, and that these reforms, I think, still fail to tackle the attraction of alternative mechanisms that are available to companies such as private equity. The consequence of this is that I think it seems to me that IPO numbers are unlikely to rise dramatically as and when these reforms are introduced. Perhaps the future for UK capital market regulation may therefore not look quite so different to the past as the Hill Review and other consultation documents might have hoped for. Thank you.